Today in this video we will discuss the journey of contempt law in Pakistan. It holds a very unique position in Pakistan legal system. It encompasses the concept of court and the proceeding must be respected and obeyed. Pakistan contempt laws have evolved over time, reflecting country's political and legal landscape. This video dives into historical record of the contempt law in Pakistan, exploring its origins, key milestones, and contemporary applications. The roots of the contempt law in Pakistan can be traced back to the British Raj. The Contempt of Court Act 1926 provided a legal framework for addressing acts and statements that undermine the authority of the court or its proceedings. After Pakistan independence, the above fourth mentioned act remained in force until it's replaced by the Contempt of Act Ordinance 1964. 1964 Ordinance expanded the scope of contempt to include any conduct that obstacles or interferes within the administration of justice or impugns the integrity, independence, or impartiality of the court. It also introduced a distinction between civil and criminal contempt, with former entitling a fine or imprisonment for a specific period and the latter involving more than severe punishment. Due to military dictatorships, the General Muhammad Ziaul Haq, the concept of contempt of court was weaponized to suppress dissent or curtail freedom of expression. The Federal Shariat Court was established in 1980 with the power to declare laws un-Islamic. Numerous individuals were convicted of contempt for criticizing the rulings or questioning the authority of military governments. After Ziaul Haq's death, Pakistan democratic institutions were gradually restored. The Contempt of Court Amendment Ordinance of 2003 aimed to curb the excess of martial law era. It established a two-tier system of review, allowing convicted parties to appeal to Supreme Court. In the past 2 decades, contempt of law in Pakistan has been involved in high-profile cases. Notable incidents include the conviction of former Prime Minister Mia Mohammad Nawaz for contempt in connection with Panama paper cases 2018 and the imprisonment of journalist Saikar Alnwar for criticizing military role in 2016. While contempt law remains an important tool for protecting integrity of judiciary, there have been concerns about potential abuse of and its impact on freedom of speech. Critics argue that the law is often applied selectively, targeting individuals, while challenge the powerful or express dissenting views. In response to these concerns, there have been calls for reforms to the contempt of court law in Pakistan. Some proposed changes include narrowing its scope, including public interest defense, and establishing clear guidelines for when contempt proceedings are appropriate. The debate over contempt law in Pakistan is going, reflecting the tension between the need of protecting judiciary and the importance of the upholding fundamental rights. Balancing these competing interests is a complex task that requires careful consideration of country's legal history, social content, and democratic aspirations. Contempt law in Pakistan has been shaped by complex interplay of history events, political dynamics, and constitutional principles. Its evolution has been marked by both the need to protect integrity and the judiciary and the recognition of the importance of freedom of expression as Pakistani continues to grapple with the challenges of democracy and the rule of law. The future of contempt law remains uncertain. However, ongoing debates and call for reforms indicate a growing awareness of the need to strike a balance between these essential values